Good morning, everybody. We have successfully completed up to Article 51. Article 36 to 50 relate to directive principles of state policy, and Article 51 relates to fundamental duties of citizens. Yesterday we discussed these do not have force of law. These are only ideals for the government to keep in mind while formulating laws for the country. I would like to discuss the present conflicting issues because that is the very purpose of my starting this web series. Now the whole country is looking to the Honorable Supreme Court of India for its judgment in matter of reference by Her Excellency the President of India, Draupadi Murmu. She has added 14 questions to the Honorable Supreme Court for its opinion under Article 143. That situation arose because of a Supreme Court judgment in Government of Tamil Nadu versus Union of India. The issue was that the Governor of Tamil Nadu have withheld the bill sent by the Assembly for an unusually longer period. Honorable Supreme Court said that the Governor has to exercise his options within 3 months. Otherwise, the bills are deemed assented. We know the options before the governors under Article 200 and 201 are that under Article 200, he can either assent to the bill, return the bill, or withhold the bill. Under Article 201, Governor may refer a bill to the President of India. Of course, he has such power under Article 161, where there is ambiguity. He has to refer the matters to the President of India and he has to act according to the advices or instructions of the President of India. But the Honorable Supreme Court said that assent was not necessary after 3 months. That means there is no need for a governor to be there for any state. I regretfully bring to your notice that there is abysmal ignorance of Constitution and basic tenets of democracy in India for the last 75 years. It is true. Honorable judges are experts in law. But where do they find the basic principles of democracy or socialist, secular, federal, unitary? These things are not defined under any law, at least in Indian law. But unfortunately, the judiciary is delivering judgments on these political and technical issues. The worst misunderstanding in this case is that the plaintiff is the government of Tamil Nadu. This itself is a wrong statement. Government of Tamil Nadu should not be represented by the legislative leader. Government of Tamil Nadu must be represented by the governor of Tamil Nadu. So against whom this case is being filed? It is against the governor. And the cause title should be Governor versus President. So, to call the set of Council of Ministers constituted by the majority in the Assembly, headed by the Chief Minister, should not be called the government. Government is always under the governor of that state. Any activity must be done in the name of the governor under Article 166. Abysmal ignorance of the constitution ruling the country, and there is abysmal ignorance of basic tenets of democracy. In a democracy, there should be separation of powers. Honorable Supreme Court said that we have to uphold the principle of separation of powers. When you said that the executive, namely the governor, is bound by the advice of the legislative leader, where is the question of separation of powers? Where is the second authority? You have made the second authority subordinate to the legislative leader. This is not democracy. When a governor does not assent to bills, or when he withholds the bill, the proper course of action for the chief minister shall be to go to the people, to the masses, and educate them that he has introduced and passed a very good bill for the welfare of the state and the people. But the governor, as a villain, has stopped the bill from becoming law. And he will plead before the public that you should protect democracy. Please do not vote to the party of the governor, namely the party of the President of India. You vote only to us. Then we will bring our own president. He will appoint a governor whom we want. We will get the bills passed. In turn, the governor should go to the masses and say why he has withheld the bill. How it is against the welfare of the state and welfare of the people. Ultimately, it is the people who should decide whether the legislative majority leader is right or the governor is right. It should be decided by the people of that state. That is the beauty of democracy. In America, legislative power of America is vested in the Congress of America, and the executive power of America is vested in the President of America, respectively under Article 1 and Article 2 of American Constitution. Where a Congress passes a bill and sends it to the assent of American President, he has to assent to it or return it with or without suggestions. Otherwise, the bill is deemed accepted. But the same principle you cannot apply here, because in America, that is a perfect democracy. But India is not democracy as on date, because there is no executive. Only legislative leader is ruling. We have made the executive subordinate or secretary to the legislative leaders. Unfortunately, elected executive is made secretary to the legislative leaders. There, the opposition parties might be in majority in the Congress. President belongs to some other party. So the bill was passed by the opposition parties. It is, as such, it is necessary for the president to pass such bills. And moreover, their system is such that the term of President of America is 4 years, whereas the term of the Congress, and especially the House of Representatives, is only 2 years. There is also Senate like our Rajya Sabha, and its term is 6 years. 1/3 of the members retire by rotation every 2 years. So both are identically equal systems with one difference, that the term of president is 4 years and the term of, like Lok Sabha, their House of Representatives, is 2 years. That means while a president is in power, at least 2 elections will take place for the House of the People. President of America may not get a single seat in Congress, yet he will rule the country. His powers will not diminish, because majority in the legislatures has nothing to do with ruling the country by the executive. This is legislative and that is executive. The powers are distributed. Legislative power is with the Congress. Here the legislative power is in the parliament or the state assembly. The executive power is vested in the governor and the president. So majority has nothing to do with the ruling of the country. Moreover, is it necessary to pass so many enactments every time? There are already so many innumerable laws in the country. Why new law is necessary? As such, if new law is not passed, nothing will happen. Heavens are not going to fall. You may get a doubt that what about the budget or finance act of each year? That again is a misunderstanding prevalent in India. That is not finance act. That is budget under Article 251. It is called annual financial statement. In the Constitution, we call it popularly budget. There may be discussions on the budget, but it need not result in passing of any enactments unless there are new taxing laws, etc. They are entirely different. Whereas budget itself does not lead to passing of any act. So, new enactments may or may not be necessary. And moreover, in India, the difference is that in America, the opposition party is passing a bill. In India, the party which has majority and which is represented by the chief minister is passing the bill. That means, supposing when a chief minister has majority in the assembly, his word is becoming law. We have seen in Tamil Nadu sometimes, Jayalalitha got only one seat, while all the rest of the seats were won by DMK. So there won't be opposition in the assembly. His word is becoming law, and you are demanding that whatever he says, governor should accept such bills. So where is democracy? Where is separation of powers? Why this? Supposing he passes a bill, and Tushar Mehta, of course, in this case raised a doubt. Supposing the state assembly passes a bill stating that we do not want to be part of India, should the governor assent to such bill? He rightly questioned, but that is only partly true, but there is a lot to that under the Constitution. So these majority leaders, what they do? They make laws, issue GOs. That is the one more again most misused term. GO must be a governor's ordinance under Article 213. Every circular issued by a departmental head is called a GO. What is this government order? There cannot be a government order. There should be only governor's ordinance. All others are circulars like income tax CBDT circulars. So the man who is in majority in the assembly is passing a bill, allocating all sand reaches to his followers, all granite mines to his followers, giving all contracts to his followers, taking out from the earlier contractors on some allegations, or otherwise he will not pay the bills to the earlier contractors. He will appoint all his henchmen in very, very important positions. If you think this is democracy, even God cannot save this country. With this false feeling of becoming chief minister with majority in the assembly, the rich communities, rich families are forming regional parties. They are treating that region or the state as their ancestral property. They fund 150 people with 10, 20, 30 crores for the elections to contest. They will purchase votes at the rate of 1, 2, 3 or 4,000 rupees and come back winning. And then the gang leader says, people have preferred us to rule this state. So they hog all resources to themselves, to their friends and relatives, and sell the properties on quid pro quo. The recent trend is they are even selling away the lands of the state in favor of their friends, relatives, and other corporates under quid pro quo. This is not democracy. The president should be a pakka political man because he is an elected man, he is not any nominated man. He has to solicit votes from MLAs and MPs unless he has relevance of their being legislators. How can he go and solicit their votes? He is necessarily a politician. So governors have all the powers vested in them under Article 153 as appointed by the President of India. Article 161 says that a governor shall act in accordance with the advices of the President of India. Remember, advices can never become orders to their superior. Advices by the servants, would they become orders to their masters? Ministers are appointed by the governor, removed by him and at his pleasure under Article 164. It is he who allots jobs to the ministers under Article 166. And Article 163 says that the duty of the minister shall be to aid and advise the governor. But the condition is that the Council of Ministers shall not be entitled to advise the governor in matters which require the discretion of the governor. That means these people are very low level people, like a casual labor. They are not supposed to advise the governor in matters which requires the discretion of the governor. So there is difference between American and Indian system. There the bills are passed by the opposition parties mostly and assented to by the... In India it is different. Majority leader who is ruling the country is also passing the bill. So that means he can make any law whatever he wants. This leads to oppression of the opposition parties. We have seen in Tamil Nadu Assembly, Jayalalitha's blouse was torn by MLAs in the assembly. She kept that in mind. In the next elections, she got all the seats. Karunanidhi got 1 or 2 seats. And then her police have removed his undergarments and bet him. This is the kind of activities of these gang leaders. These people belong to one party. Necessarily, president is a politician and governor is a politician. So some enactment, the majority leader may pass a bill, but the governor may not want that. He can withhold it. The option for the legislative leader or the governor is to go to the masses and explain their stands, respective stands. It is for the people to decide their fate in the next general elections. This is the beauty of democracy. Especially judiciary interfering with legislative procedures is unwarranted. Constitution specifically prohibited the judiciary from interfering with the legislative proceedings, even if they are irregular. It is under Article 122 and 212. Even if legislative procedures are irregular, judiciary is not supposed to interfere. Judiciary is not supposed to summon the executive, namely the governors and the president, to the courts. Does it mean that you can pass orders against them without summoning, without hearing them? This is a ridiculous thing what is happening in India. Thank you. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. I will be glad to reply to your worthy comments. Thank you.